All right, we are live. What's going on YouTube, Facebook, Twitter? Welcome to the Stamping Academy. Today, what we're going to do is we have Kerren Archuleta, principal attorney with Credence Counsel. In today's class or presentation is she's going to teach you how to the basics to estate planning and how you can set up your living trust. Before we get started, Kerren, thank you for joining us today. How is your day going so far?
Good, good. Thanks for having me on your platform to be able to share this information.
No, the pleasure is all mine. I know we have limited time. What I'm gonna do is the floor is yours. I'm gonna shut up and I'm gonna let you go to work.
All right. So I'm just going to talk about the basics about what estate planning means, why it's important, and why you would want to know this information. So first, a little bit about me. My name is Kerren Archuleta. I am a solo attorney for the law firm Credence Counsel, where I do trust and estates law. I was born and raised in Stockton, California my entire life. Very tight-knit Indian community. Family's been at the core of everything that I do. And so estate planning just goes hand in hand, and the passions and who I am and what I enjoy doing. So most Americans view estate planning kind of like as a reactive way, right? So they think that 2/3, they do realize that there's some importance of a will. And then 1/3 of Americans actually have some kind of plan in place. A lot of times they feel that you need to have a lot of money in order to have an estate plan. They don't know how to start, where to start, what they will or trust, or basically they haven't got around to it. So that's kind of like the idea, general idea is either I need to have a bunch of wealth or I need to be elderly in order to even start a will. And so if you didn't have anything, basically, if you never created anything and you find yourself in a situation where you have lacked capacity or you pass away, this is basically the default from California. So in a situation of incapacity, meaning like you are still living, but you no longer are able to execute documents on your behalf. You had some kind of health crisis. We just went through COVID. A bunch of people had trouble and what's ailments and sickness, and no one was able to really help them out or advocate for them while they were in a hospital. Not only not physically able to be there and see what was going on, but also just had their hands tied legally because they weren't able to do anything for them. So in that situation, you would have to seek out court approval to get a conservatorship to be able to help your loved one in order to sell things on their behalf, talk to financial advisors, get personal care for them, do anything on their behalf. So that conservatorship is something that is a very specialized area of law, something that usually requires an attorney to help you. The court is watching over your every move. You have to provide accountings, and it's charged at an hourly fee, something that a simple power of attorney could have completely avoided. And then also, if you pass away without anything in place, and most people who own any kind of property or any asset above 184,000 will have to go through the formal probate process. So probate, what is it? Why do we want to avoid it? Why is it even something we should be concerned about? So one, it's a very lengthy process. It can take from anywhere from 1 to 2 years. The court calendar moves very slow with these matters, and it's public, so it can be contested. So meaning if you have a trust, it's private. You don't have to worry about creditors coming about and making claims. Family can start to create some litigation, some reasons to start filing things and create more problems, and it can be extremely expensive. So compared to setting up an estate plan and probate, we have an example there in that slide. It basically says that if you own a home in California, which is anywhere around 3 to 500,000, a couple bank accounts, cars, so an estate of about 500,000, would have to pay statutory fees. So meaning that the state law, California law, has set by statute what attorneys get paid and what the people who are representing the estate get paid. And so each of them are permitted to take the same amount of money by state law, and that would be about $20,000 for a $500,000 estate, which is about the average estate that goes through probate. And so again, the planning timeline, right? So we talked about the importance, we talked about what probate means, and now when can you plan for it and when can you basically not plan for it. So during wellness, you're healthy, you've got capacity to execute these documents, and you understand your affairs. That's the perfect time to get these documents in place. As you start becoming sick, as you start becoming diminishing in capacity, oftentimes you get phone calls where families are saying, my dad or my mom or my grandparents are no longer feeling well, and I really need to get something in place so that I can help them. But at that point, it's too late. There's nothing we can really do. We can't execute powers of attorney on their behalf, because they are the ones that have to sign that authority over to you. And the only way to get it at that point is to go to court and go through the conservatorship process. So what documents make up this estate plan? So you've got your trust. You may have heard on the internet all over the place that living trust or revocable trust, or you set up a trust, there's jurisdiction trust. Trust is thrown around everywhere. But this document alone is the one that holds all of your assets in it, and it gets administered when you pass privately. A will, there's a common misconception that a will alone will just avoid probate, and that it doesn't. What a will can do, though, is it can make your wishes. So you can say, who you wish to receive certain parts of your estate. You can nominate a guardian in a will, but a trust is one that holds your assets and distributes your assets. Well, all wills go to probate. The only thing they can do is make your wishes for you. So the state will no longer be able to decide who gets what. Your will can do that. Your trust can do that. But a will alone will not avoid probate. So you need them to work together in order to be completely removed from the court process. Now we've got powers of attorneys for your health and finances. Again, those are the two that work for you when you're living, because you don't want to be in a situation where you no longer have capacity, but you're still alive, and you really have all these assets that could be working for you, but now you don't have the authority to sign on your behalf. You can't talk to people because they're reluctant to speak to someone who lacks capacity, but you need these things, and you can't, basically access them without having this power in place, or, someone has to go petition the court and get a conservatorship for you to work for you. So we nominate a conservator and we get these powers of attorney. Also, this HIPAA authorization, it seems minor, but it's actually a very big deal when you have, again, health issues and someone needs to be able to speak with these providers and be able to advocate on your behalf. They got flooded with COVID, the medical professionals with so many different cases, so much going on, and it really could have used a lot of communication with people who actually sit and care for their family members and know what medications to take, understand their health issues, and could have spoke more freely without these barriers in place with privacy laws. So having this HIPAA authorization in place, being able to just hand it over to a medical professional can really help you in a time of need. A nomination of guardian. So this one is for all of your minor children. So if you date night, you're out and about in potentially a car accident or something happens and your children are with the babysitter, well, if you don't have anyone nominated or put in place, you don't make it back home that same night, whatever's going on, police are having to come into that home, and we don't know where those kids are going. Worst case scenario, which is I've actually seen, foster is a temporary place because they don't know who they go to. They don't have numbers for people. Maybe your family lives out of state. Having something like this in place is really critical for your minor children so that they can be, with family or people that you trust. And then we've got a personal property memorandum. So that one is basically California law allows you to itemize every single asset that personal property assets into a memorandum that basically says, so if you have something that is really kind of sentimental to you, or something that is, some family heirloom of some sort that you want to make sure certain people get, you can handwrite onto a memorandum what it is that you wish for your family to receive, and then name the beneficiary, date, and sign it. And so long as we also mention that in your trust, you can take that document and it will work for you for the remainder of as long as your trust is active. And there's other documents that will help kind of effectuate the plan. So all of these documents together, the purpose of them are to keep you and your loved ones out of court, and be able to privately administer your estate, leverage your estate, so that when, if you pass, your family can just immediately take over and be in your place. So I think we touched a lot on the remainder of the meaning of each document, but basically power of attorney again is very critical, because when you need the money in your account but you can't access it, someone can immediately be able to do that with this authority. Sign checks, talk to financial advisors, make decisions on your behalf. Again, if you find yourself in a situation where you're in nursing care, and had a client actually that was in a Medi-Cal facility that was not cared for very well, but he had the means in order to be cared for in a better situation. However, he didn't have this power in place. He was going to have to get a conservatorship for someone to sell his home in order to have that money to live the end of his life in a better way. So didn't have it in place. You have to have someone who will actually be willing to pay an attorney to help you reach your money. So it seems like a minor thing, a power of attorney, but it's a big, big deal when it comes down to your life and when you need it, as opposed to really distributing your estate with the will and a trust. So these are things that are going to work for you on your behalf when you can't do that. Again, the healthcare directive is very similar to the power of attorney. The difference here is basically you are in a state where you're incapacitated and you need someone to start making medical decisions for you, right? And it's emotional. It can be difficult to have to make end of life kind of decisions or decide for you. And if you have a family that's a large family, not everyone may agree with what the choices that are being made on your behalf. So this can eliminate the entire fight. You can get what you wish to be done to yourself in those scenarios. And so you make all your wishes in this document and give the authority to the appropriate person that would be emotionally sound and be able to start jumping in your shoes and advocating for you in emergency situations. So let's see. Again, the revocable living trust. So there's a revocable living trust, and then there's an irrevocable living trust. I'm sure you may have heard these terms online somewhere, but basically what it means is that you have a trust that can be revoked at any time during your life, and as your life changes. So today, maybe you have minor children, you get along with everyone that you've named as beneficiaries, and you wish for certain people to receive certain assets. You put certain assets in your trust, but then, maybe things change. People are poor money managers. There's a risk of liability for certain people, divorce, children, or you may not want to give the assets to. So you can revoke your trust at any point. You can amend it, you can change it. An irrevocable trust, on the other hand, is something that can't be revoked or amended or changed after it's been created. And it almost acts like its own legal entity. We'll have to get its own EIN, we'll have to pay taxes. It's really a strategy when you start reaching really a lot of liability or have a really large estate that you're trying to diminish, because it essentially removes all of what you put inside of it from your own estate. Okay, so how does this all play out? So we've got a trust. You got all of your assets in there. You've got your home, your bank accounts, your cars, all of the things that make up your estate, your business. And then you've got a trustee. So your trustee is the person that will be you while you're living. You'll manage your own trust, just like you handle your own affairs right now in a revocable living trust situation. And you'll name a successor trustee. So when you're no longer either incapacitated for whatever reason, temporary, permanently, someone else is going to start acting on your behalf in your trust with all your assets in it. And then you've got beneficiaries of that trust. So the people who will actually receive the assets of that trust. You while you're alive, your loved ones when you're no longer living. You don't want to put in your retirement account into this trust, because retirement accounts are subject to certain kind of rules and distributions. And if you name the beneficiaries directly, oftentimes their tax bracket is going to be at a better rate than a trust bracket, where trusts have to pay taxes when they become irrevocable. And if the dollar amount is very high in a trust, it will have to pay on the income in that trust. So basically similar, how does the trust accomplish the client's goals? Your goals really are to remove your estate from having to go through court process, to be able to be in control of your assets, so that you are the one who decides who receives what, when they receive it, how they receive it, and be able to do all of this privately at a way lower cost. Whereas in probate, sometimes families find themselves in situations where the only asset may have been the home, and they've got these large, exorbitant fees and costs that they need to pay. And because of that, they're no longer able to keep the home. They have to sell the home in order to pay all these expenses. Whereas in a trust, you set it up so that you pay the fee. It's usually flat fee, at least with our firm. And then it's done. You have your trust. That's it. And that's the only fee that will be related to it, other than administrative costs at the end. And then you can leverage that home. You can put all of your children's name on that home. When it comes time to administer, you can make it so that certain children only receive at certain ages. So if you don't want minor children to receive money, they'll get it in a sprinkling fashion, maybe 25 years old, a third of it, the next third at 35, and the final distribution at 40. So it allows you to do a lot more in a trust than if it went through probate. And so again, the will again is this, I don't know if it's something that's been kind of, I guess, publicly spoke about, like the reading of the will, or there's this idea that a will is everything. The will is what avoids probate. I need to get my will done. Although a will is important, it is a legally binding document, and you can make your distributions how you wish, and you can make your wishes there. You can nominate guardians there. It is powerful in those kind of ways, but a will by itself, again, does not avoid probate. All wills go to probate. Even a will that's created in an estate plan will get lodged with the court. The court will view this will. It's called a pour-over will. We create it with a trust. It's going to state that you have a trust. And the court's going to see you have a trust, and that's the end of that. They don't open up probate. There's nothing that's done. It's just completely just filed, stamped, received, and you move on. Your family moves on and administers everything privately. Okay. I think we touched a lot on the benefits of a trust. Again, you can set up sub-trusts for your children. You can protect your children from inheritance from predators, creditors, divorce, money management. your children with disabilities. So if you have a special needs child or someone who's receiving public benefits, you can make sure that they continue to receive those benefits, because there's income thresholds that if they received over a certain amount, they'll lose those benefits. And oftentimes kids who have, or even turn into adults, are unable to work, so they really rely on that public benefit and the income and the insurance that comes from that. So we don't want to ruin that by giving them your assets on your passing. We can preserve that and give them supplemental income by having this special needs trust set up for them to receive. It's a supplemental needs trust. Again, no court involvement. And let's see. We got, these are just additional kind of reasons to, considerations for why you would want to do this. So the minors, again, temporary guardians, permanent guardian, you can nominate those in the nomination of guardian. So the reasons why you'd want to have that is a short-term period for someone to be a guardian, while because you need a parent or a family member that's out of state to come and take that child, or various reasons. A permanent guardian is someone you want to name for your minor children, because that passes your child's decision-making power while they're unable to, and someone who that you decide can care for them, versus if you're no longer here, having people battle as to who should be taking care of that child, especially when you're gone. A lot of times people latch on to that child as if the person is still within that child, and can get pretty ugly. So let's see. So these are all different reasons that that you'd want to have your beneficiaries may need extra help with managing their money, blended family situations for your trust. So if you have, it's a remarriage, you both have children from different marriages, and you want to make sure that if you were to pass, that your children are going to receive your estate, and that if that spouse gets remarried, that spouse isn't going to do anything to disturb your community property interests. So a lot of reasons to really have this in place, because default rule is that it goes to the spouse and then the other children. Maybe you create a lot of fights. So in this blended family scenario, you can really spell out what would happen in all this. If you were to pass away, what would happen to your interest? And then we kind of touched on special needs. And then business owners, again, if you are a business, real estate property, bank accounts, all these things are going to be going into your trust. So if you have any sort of business accounts, or you have a business that you want to continue to succeed when you are no longer here, maybe you have family members who are also working within that business, you're able to account for all of that in your trust and make sure that it continues to go. You have a succession plan for that to continue running. Pets, some people feel that, very near and dear to their pets, and they're able to account for the care of their pets in these trusts, or actual pet trusts. So you leave a certain dollar amount for your pet, and name a person who would care for your pet. A lot of it's honorary, because some people may not want to do it, and you can't force people to do that. And yeah, so basically, it's a lot of paperwork on the front end to get yourself organized. You're going to want to know all of your checking accounts, put all the account information, your retirement, locate your life insurance policies, check all these things to see that you've named a beneficiary on these accounts. You've named someone who's still living, someone who you still want to receive all these assets on your checking account. Make sure you've got people listed that you trust to either you can put in a pay on death, or we list them in the trust if it grows, so that you're not worried about any issues with probate just because of your checking account. And so you'll also want to find your property deed. Real estate is really like the biggest reason to create a trust, because the real estate alone is going to have to give you a reason to open probate. And a little quote: plans are useless, but planning is essential. Unfortunately, many people learn that the hard way after it happens.
Yeah.
Yeah. So yeah, I mean, I would have opened it for questions, but
Yeah, I definitely have a couple of questions. First off, thank you. That was a presentation, and there's a couple of things I still. Number one, I did not know that you could set up a trust for your pet. That is something I've never heard of. I didn't even know that
yeah,
existed.
yep. You can make sure they're all accounted for. There's a certain dollar amount. I mean, you have to think about how long they'll live, and then you
Mhm.
can only give so much money to a pet that's going to live. You know, they're not going to be able to go on vacations and get a passport and all of that. But yeah,
Interesting. Another thing I want to touch on, the emergency aspect. I'll give you a quick story. Just recently, I did a estate plan signing for a client, and unfortunately, they had a stroke. So they had a stroke, and thankfully, they were still able to speak and still didn't have any restrictions in regards to their ability to fill out their. You talk about just touch briefly on the urgency that people should have, especially when you get into those elder years, and why it's important for you to actually be proactive in getting this set up, as opposed to waiting till you actually get to the hospital, where you may be in a situation where you may not be able to speak for yourself. You may not be able to fill out these documents, and you may just family may not be on the same page, as far as who's going to be a beneficiary and who's going to get what. You just speak to just the urgency that people should have, and the urgency they should have in getting this set up
yeah.
ahead of time, as opposed to waiting till like the last minute to get this taken care of.
Yeah, it goes back to that quote of that plan is useless, right? But planning is essential. But I mean, like, people in the first slide and mentioned that people know it's important, right? We all know this is something we should probably do, but we just kind of, I don't know, instinctively we just don't want to deal with it, right? There's lots of things that we have to put together. We got to talk to an attorney. I don't know where I'm going to talk to an attorney. How do I even get in touch with an attorney that does this? And I just don't want to go through that process, but it's really a lot easier than it seems. I mean, it does seem daunting. It's something people don't want to deal with. But when it comes down to the actual troubles that are created with not doing this, everyone wishes that they would have done something about it when they had the chance, right? So,
Right.
just take it into bite-sized pieces. Just like, what's a power of attorney? Let me think about how I would do that if I need to just get that basic part of things done. And then if you own real estate, you have minor children, it's kind of a no-brainer for me. I mean, just because I see this every day and I see the downside of it. But yeah, I mean, it's unfortunate when you see people going through probate and they're like, man, I can't believe, how crazy this is. Like, I have to wait a whole year before my family's estate. He only owns, XYZ, and wasn't even that much. And there's so many of us. And why do I have to do this? It's like, that's just the process if you don't have it in place.
It's unfortunate.
Yeah.
Unfortunate. I got a phone call. I got a phone call yesterday from a person who I think they set up their trust, or they set up a power of attorney. So I guess it's like a family issue. I guess this lady calls me. She finds out she was moving her aunt from a nursing home, because I guess the aunt was being mistreated, into another facility, or to her home, right? And she was basically asking me, right, that they already had set up this trust, and I guess the niece that her niece already had was already going to be her, I guess, her attorney in fact, or her fiduciary. And initially she was supposed to be the fiduciary, but she was removed, right? But then she comes back years, I guess 3 or 4 years later, and wants to be included back in the trust. Now, in a situation like that, when you have those family disputes, if they already been removed before, would it be up to the principal to say, hey, if I want to actually include this person again, or if it's already been set in stone, that just is what it is?
Yeah, so and this is the kind of thing that starts these litigation issues, right? So if now we've got somebody who doesn't really have that capacity anymore, but they executed a document years ago and they even removed somebody, then there's so many red flags and suspect issues that can create way too much litigation. And the only person who can remove that at that point, the only person who can always remove it is going to be the principal. There are situations where the power of attorney has the right to do literally everything on your behalf. So they may be able to, but if that person is no longer in that role with the power of attorney, and depends on what kind of powers they have. There's general powers, there's limited powers. So if they had broad range to do everything, they can sell your house, they can do everything on your behalf. But if they're removed, then it's up to the principal. You can't appoint yourself after you've been removed. So, yeah, that's a touchy thing too. I guess for notarizing, you really kind of like got to be on your toes for certain things too. Like, what's going on here? What am I notarizing? Because you can get yourself in a situation too where you're being subpoenaed and you have to, show your ledger and all of that.
No, that's a fact. That's a fact. That's why I always try to encourage notaries before they even take on these type of signings, whether it's a estate plan or a power of attorney, to actually like do your pre-screening, because they could tell you one thing over the phone, and then when you actually go to the actual signing, it's a completely different situation. It could be a little awkward, and it kind of puts you in a place where you don't want to put your commission at risk.
Yeah, no.
Because like I said, down the line, you can't be subpoenaed. Get subpoenaed. Your commissions, they can the person or the victim can file a complaint on your notary commission. So it's always important to just do your due diligence, because these situations are could be a little scary if you don't know what you're doing or just know how to go, just how to handle it in general.
Yeah, you just kind of got to your senses about if it doesn't feel right, something doesn't seem right.
No, definitely, your spidey senses got to be up.
Yeah.
Another one. Can we talk about probate? It's how that on, because I hear probate is a potentially 6 to 8 month long process.
Yeah, it actually can take even longer, and that's just with uncontested, meaning there's no fight. There's family that just waiting for this whole process to go through the court system. Had one filed in 21, and it just closed in 23. No fights, just one. Parents pretty much were the only beneficiaries, and we were just waiting for the court's calendar to move. So it's just it's not a fun process, and meanwhile everything's frozen, right? We can't do much to it. You can sell property if you get full authority and you get waiver of bonds, and there's certain ways to be able to sell property. But if you wanted to just you're grieving, you lost somebody, and you want to just move on, you can't do that with this process. And then not only that, but you may be forced to sell a property that may have been a family home for years, and you want to be able to keep that, but now that's the only asset, and you have all these fees that you have to pay just because it's going through probate. And so there's liens or other things that would get attached to the home, or the home would have to be sold. So yeah, it's a horrible thing when it actually comes down to it. It's also, a lot of attorneys talk about this estate planning and the lack of awareness of it being like a social justice issue, because a lot of people who don't have a lot of means have not been educated of the importance of estate planning and how it can help your family grow, basically. You hear these trust fund babies and this word around it, but it just essentially means their family learned the importance of this plan, and they're able to leverage their assets so that every generation is just growing, right? Whereas, you cut off this family home because now you didn't have a estate plan, you had to sell it, and you have, everyone's on their own. Right. Versus being able to rent that property out, make some money, get their own, and just build from there.
Scary.
Yeah.
And then also too, let's say if we get to the end of probate, what the family was initially supposed to receive, I'm pretty sure the courts is probably taking a huge percentage of that with court fees and probate costs and things of that nature before they even receive what they were supposed to initially receive in the first place.
Yeah, no, definitely. That's the biggest thing. I mean, the fees related to probate are the killer in the end. I mean, compared to what you would be able to absorb if you had no probate process, as well as just the fight. It's not in a public court; it's private.
Yeah.
Creditors' claims, the length of time to just settle the estate. Um, People get involved. There's loan officers, there's probate referee, there's an attorney you have to deal with, there's realtors, there's just so many factors that you just, after losing somebody, that's not something you want to go through, and having to, you know, settle the final affairs. You got your own life to deal with, and let alone all these other things now that you've got, kind of burdening you.
Incredible.
Yeah.
I mean, I think that's all the questions I have. We had someone that left a comment that said great information. They said thank you. Again, this was a presentation. I have a better understanding of what I need to do in order to set up my estate plan and set up my trust, because I definitely need to set one up.
Yeah.
I just think it's just very important because, like I said, I do a bunch of these type of signings, and a lot of times, thankfully, for the most part, it's a kind of 50-50. Normally, I'm either going to the client's house or I'm going to the office to do the signings. But more times than not, I find myself either going to hospice or I'm going into a hospital setting, and they're waiting until they're like absolutely have to do this, or it's too late. So I
Yeah.
really encourage everyone that's watching this to be proactive. Set up a consultation, even if you're not ready to just have the funds, get everything set up right now. At least knowledge, get know-how, at least prepare yourself so that way you have your ducks in order. So that way, by the time you do sit down with Kerren, she's going to make sure you're well informed and have everything that you need to get set up.
Thank you, Nathaniel. I appreciate you having me on your platform and sharing this info. Hopefully, lots of people learned something that they didn't already know.
No, definitely. I hopeful people are going to be screenshotting this as well. Have the ticker at the bottom. Make sure you email Kerren. Schedule your consultation. See where you're at to do. Don't wait till you're in the hospital. Don't wait till things get dire to where it's an emergency, where you have to actually get this done. Like, be proactive, get this taken care of, and let the rest fall in place. Before we head out, did you want to leave anyone with any parting words, any way how they can get in contact with you besides email or to social media, things of that nature?
Yeah, so I don't know if this works on the slide that's there, but it's my dot card, so it got pretty much everything there. I do I haven't been posting, but I do post quite often when I get back into the rhythm of things, on just tidbits of like what certain documents mean and how they work. So if you just kind of want to continue to learn more, you can follow me on my social media channels and just watch some videos. If you have questions, maybe you have family members or friends that can really benefit from this. So I would appreciate if you just share, the information.
Yeah, definitely. If you're watching this on YouTube, make sure you like this video. Make sure you subscribe to our channel. Again, please reach out to Kerren for all your estate planning needs, any information or question that you have. I'm very confident in her ability to answer those questions and provide the best service for you. And until next time, we appreciate you all for tuning in. We'll see you. Peace.